Hi, and welcome to What's the Tea in L&E. I'm Leah, and I'm here today with my colleague, Fred Schutt.
Hi, Leah. Thank you. Happy to be here.
Fred, today we're going to be talking about disparate impact claims and the government's rollback of enforcement on disparate impact cases. So a disparate impact claim is where a company might have a policy that negatively impacts a group of their workforce or particular applicants.
That's right. And there's a recent case that has illustrated the government's new initiative kind of to eliminate enforcement of these disparate impact claims. And it happened in a case against Sheetz, where
We all love Sheetz. You got to stop there on every road trip. Yeah,
great breakfast sandwich.
That was not product placement, but
yeah. So Sheetz had a policy that the government had been investigating for almost a decade, where they were looking into whether Sheetz's practice of considering employees' criminal or applicants' criminal histories, regardless of whether they were convicted, had a disparate impact on applicants of color.
But Fred, most companies run background checks, right? So, like a company can have a background check, right? So what's the distinction between running background checks and what Sheetz was doing?
Sure. In this case, Sheetz was considering criminal history, but not whether that resulted in conviction. So the government's position in the past, or what they were investigating, was whether considering that criminal history without conviction, if that was having a disparate impact on applicants of color.
And that's because individuals of color are more often falsely charged with something. Is that fair to say?
That's exactly why the government was looking into it. And for almost a decade, the government was investigating that. And then just recently in this case, the government moved to withdraw from the case in accordance with the new executive order to kind of stop enforcement of those kinds of cases.
So we have the EEOC, the Equal Employment Opportunity Commission, which was investigating this, probably pushing Sheetz to make some changes, and is now kind of withdrawing. Fred, with the government the EEOC pulling back on disparate impact claims, what does that mean for employees?
So for employees, it means that they're less protected than they were a month ago. And this is an example. In this particular case, the case is going to continue because individual employees are going to bring the lawsuit and continue it. But the EEOC in the past has kind of taken on, or recent years has taken on, kind of some of these systemic discrimination cases that are often based on disparate impact, and so those kind of claims are going to kind of stop.
Yeah, and that's unfortunate, right? I mean, they were pursuing situations where a company has one practice that may have hurt tons and hundreds of thousands of individuals, right? And so now, or thousands, and now they're rolling that initiative back. So that is going to harm employees, and there will be fewer enforcement arms going after companies with unfair policies. Now, what does this mean for employers? Can we kind of just sit back and say, all right, we're off the hook?
No, definitely not. So the law hasn't changed. Employers still can't discriminate against individuals, or can't have policies that have a discriminatory effect on individuals in protected classes. Individuals, as we've seen in the Sheetz case, individuals can still bring those claims on their own, and they can do so in a collective. They just won't have the EEOC behind them. So for employers, they still need to consider their hiring policies, their promotion policies, and make sure they don't have a disparate impact on protected classes.
Well, thank you so much, Fred. Thanks, and join us next time.